It is now my pleasure to turn today's program over to Kimberly Sendig. Ms. Sendig, the floor is yours.
Thank you, and good afternoon, everyone, and thank you for joining us today. As always, our ULearn webinars are designated to provide you with the knowledge and insights to allow you to perform your job better. Before I introduce our topic for today and our speaker, I would like to cover a few housekeeping items. If you would like a copy of today's presentation, please reach out to Jennifer Brown or to the MMA point of contact who invited you to attend today. Today's event has been approved for HRCI and SHRM credits. We will provide the information at the end of the program today. Our topic is An Employer's Guide to FMLA and COBRA. Our speaker is Stacey Barrow. Stacey is a partner with Marastus, Barrow & Weatherhead, with over 15 years of experience in the benefits and group health practice. So without further introduction, I would like to get our session started and welcome Stacey. Stacey, you may begin.
Thanks, Kim, and hello, everyone. It's Stacey Barrow here from Marastus, Barrow & Weatherhead in Boston, and we are proud to partner with Marsh & McLennan Agency to offer this series of webinars to their friends and clients. As Kim mentioned, today's topic is going to be FMLA and its interaction with employee benefit plans, including how FMLA interacts with COBRA. We're going to start out with a basic overview of FMLA as it applies from kind of a labor and employment perspective, and then we'll get into the details as to how FMLA interacts with your employee benefit plans. So the focus today really is going to be mostly on FMLA, and then as it relates to group health plan benefits, we'll talk about how COBRA interacts as well. So this topic is a little bit dense. It is very rule heavy, and so you might notice me reading from the slides a little bit more than I normally like to do here. I will, of course, be inserting commentary as it's appropriate, but just wanted to tee that up a little bit. And, of course, as always, please feel free to type any questions in through the chat box, and we should have time at the end to address them. So in terms of the basics of FMLA, in order to even be covered by FMLA as an employer, the work site itself has to be covered by FMLA, and that means you have at least 50 employees employed within 75 miles of the work site. And once the employer as an entity is covered by the FMLA, there are also requirements for an employee to meet for the employee to be covered. So the employee has a minimum service requirement of 12 months and a minimum hours requirement of 1,250 hours. And so the way that this fleshes out is that the employee has to have at least 12 months of employment, and that can be accumulated over any period of time, really. It goes back about 7 years. It doesn't have to be continuous. They just have to have at least 12 months of employment, but also in the 12 months preceding the leave, they have to have at least 1,250 hours of service. So once the employee qualifies in terms of meeting the service and the hours worked requirements, then his reason for the leave also has to be an FMLA-covered reason, and we'll get into that momentarily. So the entitlement to the FMLA leave is 12 weeks in a 12-month period, and this includes a qualifying exigency for military leave, and it provides a 26-week leave period over the 12-month period to care for covered service members with serious injuries or illnesses. And that 26-week is on a per covered service member basis per injury. So the company has a lot of flexibility here to define the 12-month period that applies for FMLA purposes, and there's really 4 ways to do it. You can use the calendar year, you can use any other fixed period like your fiscal year, you can even use the employee's anniversary date, like when he was hired, although we rarely see that used. It's just very burdensome administratively. You can use a measure forward system where you measure from the date the leave first begins, and then subsequent 12-month periods begin the first time the leave is requested after the initial 12-month period expires. Or the most popular option is the rolling backward level, where you're measuring back 12 months from the date that FMLA leave first begins, and this prevents a back-to-back 24-week leave period. So in my experience, rolling backward is probably the most frequently used method of defining the 12-month period, and then secondly to that would be calendar year. So in order to qualify for FMLA, the reasons must be one of the enumerated reasons here. So birth of a child, taking care of a newborn, including bonding time. You also you do get time to bond with the child. That generally has to be completed within the first 12 months following the childbirth. You can also take FMLA to deal with placement of a child for adoption or foster care, to care for an immediate family member with a serious health condition. You can take it to care for your own serious health condition, as well as for qualifying exigent circumstances, such as for covered military leave, and then to care for covered service members, serious illnesses or injuries, which is also known as military caregiver leave. The qualifying exigent circumstances leave also allows leave to help that covered military member prepare for the impending call to duty. Just to flesh out military caregiver leave a little bit, a covered service member is a pretty broad term that includes members of the armed forces, National Guard, or Reserve who's undergoing medical treatment, recuperation, or therapy, or is otherwise in an outpatient status, or is a temporary disabled on the temporary disabled list for a serious injury or illness. And the definition of serious injury or illness is one that's incurred in the line of active duty that may render the member unfit to perform his or her duties. I mentioned this a minute or two ago. The care for a newborn or a newly placed child for adoption must conclude within 12 months of birth or placement for adoption. Special rules exist for spouses who work for the same employer. They generally get a combined total of 12 work weeks to care for a child or childbirth or to care for an ill parent. Each can have their own 12-week FMLA entitlement for other FMLA reasons, and when you're caring for a child with a serious health condition, both spouses each get their full 12 weeks of entitlement, even if they're working for the same employer. So what constitutes a serious health condition? Any inpatient care is presumptively a serious health condition. Any period of incapacity of 3 or more consecutive calendar days that involves treatment 2 or more times by a medical professional within 30 days of the beginning of the period of incapacity, or treatment by a doctor at least once that also provides for a regimen of continuing treatment like a prescription. And we'll talk about what it means to be treated 2 or more times on the next slide. Periods of incapacity due to pregnancy or prenatal care also qualify as serious health conditions. And then any other periods of incapacity that are due to a chronic serious health condition. So things that require periodic visits for treatment like diabetes, conditions that extend over a period of time like Alzheimer's, or other conditions that cause episodic rather than continuing incapacity. And so these would be things like say asthma would be an example. Epilepsy would be another example of episodic types of situations where FMLA could apply, and it would be considered a serious health condition. So I mentioned on this slide here, a serious health condition, it requires treatment 2 or more times by a doctor, or at least one treatment with an ongoing regimen of continuing care. And an important point here is that the doctor decides whether a second visit is needed during that 30-day period. It doesn't work if the employee, calls and makes a follow-up appointment for himself. That doesn't quite cut it, and you will see that in practice if you're someone that has to administer FMLA issues. That does come up here or there. The first visit, or possibly the only visit if an ongoing regimen of treatment is provided, that must occur within 7 days of the first day of incapacity. There are also a handful of conditions that are presumptively serious health conditions, things like appendicitis, asthma, cancer, childbirth, epilepsy, severe morning sickness, nervous disorders, things like that. These are just presumptively serious conditions, injuries from accidents, and so on. So there are certain absences that are not protected by the FMLA. A condition that requires cosmetic treatment is generally not an FMLA qualified leave unless it involves inpatient care or there's a complication that results from that cosmetic treatment that by itself is a serious health condition, then that would trigger FMLA rights. And we have compiled this list over the years of hearing these reasons from employees. Absences due to an unrelated or untreated substance abuse disorder, your average common colds, headaches, your teeth hurt, your tummy hurts, your ears hurt, your car breaks down, the cat is sick. All of these, while certainly good reasons, are not FMLA protected. So just be aware of that. In terms of recognizing healthcare providers, employers have a lot of flexibility in terms of who they would like to accept as a practitioner. So not only are your MDs acceptable, but your DOs, your doctors of osteopathy, podiatrists, dentists, psychologists, optometrists, Christian Science practitioners, anyone that the employer is willing to accept as a provider basically works from an FMLA standpoint. So moving on now to employer responsibilities, there are 3 main notices that apply, and I'll get into a little bit of detail on these in a couple of minutes. There's the general notice that gets posted in the break room. There's the notice of eligibility that you provide to an employee that may have an FMLA-covered leave. And then once approved, you'll provide the designation of FMLA leave form. Other employer responsibilities include maintaining group health insurance benefits, which we'll cover in the second half of today's presentation, as well as job restoration rights. You have to restore employees who return from FMLA to the same or equivalent job function and benefits. You also have record-keeping requirements. Oops, I just skipped over one. Okay. So the first of the 3 notice requirements is the general notice. This applies once the employer becomes subject to FMLA even if its employees haven't met the 12 months yet or the 1,250 hours, once you're large enough to trigger FMLA, you have the poster requirement. If you have an employee handbook, you also have to include the general notice in the employee handbook, or you could hand it out at time of hire if there's no employee handbook available. You can post this on your website as long as it's accessible to all applicants and current employees. All employees have access to company computers. Otherwise, physical distribution of notice is required, and we do typically see a physical copy of it handed out with the employee handbook, typically at time of hire. Other notice is a notice of eligibility in rights and responsibilities. Here, the employer obligation is to provide employees with this form within 5 business days after the employer becomes aware that this might be an FMLA type of situation. It'll notify the employee whether he or she has met the eligibility requirements for leave, and if not, it'll indicate why. They haven't met the 12-month requirement, they haven't worked 1,250 hours, the reason is not acceptable, and so on. You need to tell them why the leave is being denied. The notice will also refer the employee to your leave policies, including the paid leave policies. One little nuance here that, and we'll talk about this as well in a minute, how you can require employees to take paid leave concurrent with FMLA, but the point here is that even if the employee doesn't meet the requirements of the paid leave policy, they'll still be entitled to unpaid FMLA. You also notify the employee that when they're using paid leave, it will run concurrently with FMLA. It'll be designated and counted against any FMLA entitlement, and the employee will also be notified of the maintenance of his group health plan benefits during the FMLA period. The designation of FMLA leave notice, the employer has 5 business days to provide that notice, indicating whether the leave is FMLA qualifying or not. And if the leave is granted, then you'll explain the duration of that leave, whether it's in days or hours or weeks. If FMLA is not granted, you'll have to give the reason why. And then if there's any return to work or fitness for duty certification, you'll need to include information on that as well. So employers do have a handful of rights under the FMLA. The major one is that you do have a right as an employer to get advance notice if the need for leave is foreseeable, and the employee is supposed to give at least 30 days if it's practicable. If the need for leave is not foreseeable, then they have a right to get immediate notice, no more than 1 or 2 working days if feasible, and if the proper notice is not provided, then you have an avenue for delaying or denying the FMLA leave. You have the right to get medical certification and recertification for medically related leaves. You have the right to get clarification and authentication of the information provided, but only through the employer's physician. You can also get a second or third opinion generally. There are a bunch of rules for that. So generally, if you do have any doubts as to the authenticity of the information provided, or if you think the doctor is rubber stamping it, there are avenues to get a second or third opinion, and you should talk with your counsel before you go down that road. And of course, if the employee is not playing ball and responding timely to your request, then you have the right to delay or deny the leave. You can also require employees to report periodically on their status and their intent to return. You can also insist that employees who have intermittent FMLA leave try to schedule that leave in a manner that avoids disruption of your business. You can transfer employees to an alternate position to accommodate their desire for intermittent or reduced leave. You can also require employees to submit to a fitness to return to duty report. That's a very common feature of many employers. Have something like that when the employee is out for 3 or more days. They require a fitness for duty form to be completed. You don't have to give any preferential treatment with regard to reinstatement or other terms and conditions of employment simply because the employee is on FMLA leave. So, for example, if you're laying off an entire division and you have some employees in that division who are out on FMLA, you can still lay them off. You're not required to kind of give them any special treatment simply because they're on FMLA. You also have rights to deny job restoration to what they call key employees under certain circumstances. And this is when the employee who's taking leave is so integral to your business that you simply can't operate it without that role filled. And in that case, if you notify the person before they leave that they're a key employee, that you have to fill their position, and that they might not be eligible for reinstatement upon their return, then you can take that course of action. You also have the right to require employees to use accrued vacation or sick leave, and there are a handful of rules around that I'll get into in a couple of minutes, or maybe even right now. So you can require or you can let employees choose whether they'd like to substitute accrued paid leave for unpaid FMLA time. And by substitution, we mean that the paid leave simply runs concurrently with the unpaid leave. And as I mentioned this before as well, for some reason, if the employee doesn't meet all the procedural requirements for the paid leave, he'll still be entitled to the unpaid FMLA leave. You can't deny the FMLA leave just because he doesn't meet all the requirements for, say, the short-term disability plan. Workers' comp and disability can run concurrently with FMLA. You can allow topping off if it's permitted under state law, meaning you can allow the disability payments to kind of top off the workers' comp payments. A little nuance here is that when you have an employee who is receiving disability benefits, that leave is not unpaid. And so you can't require an employee to use accrued vacation or PTO at the same time he's receiving paid disability leave during FMLA. You can permit the employee to supplement it if you'd like, where you do this upon agreement with the employee, but you can't force them to take additional paid leave when he's already receiving paid disability leave in conjunction with FMLA. So, what do you do in situations where an employee is going out on a long-term absence? First thing you want to do is check your personnel policies, employee handbook. Do they address this issue? You always want to consider ADA, the Americans with Disabilities Act, and state law considerations. Typically, when FMLA ends and the employee doesn't return to work, you're no longer required to continue the medical benefits and to hold the job for the employee, but there are ADA and state counterpart considerations. You could have a situation where maybe it's a reasonable accommodation to give an employee another few days or a week out of work in order to enable him to return to work. And in that case, you might find yourself giving some additional protection under the ADA, job protection, after FMLA ends. It's kind of a rare situation, but it does occur. And of course, with regard to your executives, take a look at the employment agreements. They also may have provisions that address these issues. So when you're considering what to do when an employee maybe doesn't return from FMLA or he's going out on FMLA, considerations include the employee's length of service. Is he a long-term employee, well-liked by the company? What are the company policies? What have they done in the past? You want to consider any employee relations issues if certain employees are deemed to get more favorable treatment with regard to their leave. That can also result in employee relations issues. The replacement cost, obviously, replacing the employee, and the burden on the supervisor if you were to take adverse employment action against the employee. Supervisor needs to fill that role or step in somehow. So what can you do when you have employees on leave? You can do nothing. You can incentivize employees to return, maybe provide like a partial disability benefit, things to encourage employees to return to work and not malinger. And of course, at the end of the day, as the end of FMLA approaches, you need to consider whether you're going to take adverse employment action or whether maybe an ADA accommodation is worthwhile to explore, or if you just want to provide the employee some extra time to return if you feel that he's a good long-term employee and you want to keep him or her. Okay, so I'm going to switch gears a little bit and move on to talking about FMLA from an employee benefits perspective, and we'll get into the COBRA issues here as well. So the general rule under FMLA is when you have employees who are off for periods of time and then they come back to work, they're going to remain qualified the same as an active employee for medical, dental, vision, and other group health plan benefits. We'll also talk in a few minutes about whether an employer or whether it makes sense for an employer to maintain other benefits while employees are on FMLA leave, like LTD and life insurance benefits. A very common approach is to maintain those benefits as well, simply due to ease of administration from the employer standpoint. So when an employee is out on FMLA, whether it's intermittent FMLA or he's out for a serious health condition, it is not a COBRA event to go on FMLA. You need two things to have a COBRA event. You need to have a qualifying event, like a termination of employment, reduction in hours, divorce, child aging out of the plan, death, etc. So that's one, you have to have the qualifying event. And then you also have to have a corresponding loss of coverage under the terms of the plan in order to have a COBRA event. And typically, people going out on FMLA will have neither of those. They may have a loss of coverage if they don't maintain it during the FMLA period, but the qualifying event does not occur until the end of FMLA, and I'll get into that shortly. So again, general rule, the benefits under the group health plan must be maintained during FMLA leave as if the employee had continued in active employment. You're not required to accrue any other benefits during that time in terms of vacation, sick leave, seniority, and either the employer or the employee can elect to continue other benefits like life and disability. It is very common for employers to continue those benefits during an FMLA leave. They're usually, list billed. It's kind of easy to take care of that. And then upon return to work, all the benefits have to be restored without requalification. And that's true whether or not the employee chooses to remain covered during the FMLA period. Even if he lapses coverage, upon his return, it needs to be reinstated. Typically, employees cannot be required to repay the employer for the employer's share of premium, but there are some limited circumstances when this is available. If the employee doesn't return to work after the leave and it's not due to a serious health condition or like the employer's action, the employer laying them off, then, and it's just the employee saying, well, I've decided I'm going to just not come back to work, then you do have an avenue for clawing back your share of the premiums that you paid during that FMLA period. These issues can always get a little bit dicey, so we do recommend you start by discussing this with your MMA point of contact that invited you today, and if you need further assistance, we can always engage after that point. So again, general rule, if an employee had group health plan coverage on the day before FMLA leave was taken, the employer must maintain those benefits. The coverage must be maintained on the same terms as active participants, and this includes basically all group health plan benefits, regardless of whether you're doing this under a cafeteria plan, all medical, dental, vision, mental health, substance use disorder, vision care, I mentioned that one. Any group health plan type benefits would be picked up here in the continuation. In terms of the premium payment rules, oftentimes when employers set up their leave policies, if they permit employees to take an unpaid leave of absence, they'll often allow them to continue coverage, but they might have to pay 100% of the premium. There might be a different contribution strategy for employees on leave or on sabbatical, but when it comes to FMLA, you have to maintain coverage and contributions at the same level that they were at prior to the leave. Generally cannot recover premiums paid by the employer. The regular premium contribution that the employee paid before leave would be continued to be paid by the employee while on leave. And of course, if things cross over into a new plan year and the contributions change for all other similarly situated employees, then you can pass that along to the employee on FMLA as well. We don't have to give him any special treatment in that regard. Typically, at least for the first few weeks of FMLA, very often the employee will have some vacation time saved up. And when leave is paid, the regular method for making contributions continues. If the employee is paying through a cafeteria plan, then they would take that money out of the disability payment and use that for premiums. If the leave is unpaid, the employee can either be required to pay the employer or the carrier directly. The employer, of course, can front the money if they want, and we'll talk about pluses and minuses of that in a minute. And you cannot add a charge for administrative expenses. It's not like COBRA where you can add that 2% on. That does not apply for FMLA purposes. In terms of the timing of premium payments, you can require them at the same time as on the normal payroll date, or you can use the COBRA cycle. I think it's pretty common when leave is unpaid to let employees pay once a month under the COBRA cycle. It is an option to allow prepayment under a cafeteria plan. There are issues when the leave spans plan years. And really any other method that the employee and the employer agree upon, including prepayment, although you cannot have prepayment as your only option. You have to give at least a pay-as-you-go or catch-up as an option as well. So there are limited instances where coverage can be terminated while an employee is on FMLA. If he fails to pay the premiums, you can terminate coverage if payment is greater than 30 days late. There is a little rule here regarding that 30-day grace period. You have to let employees know at least 15 days in advance in writing that coverage is going to be terminated unless the premiums are received and caught up on the premium payments. In terms of retroactively dropping coverage when employees don't pay the premiums, it's generally permissible as long as you have another established policy for other unpaid leaves that allow for dropping coverage retroactively back to the date that the unpaid premiums were due. And that's a pretty common policy, and I would expect that is probably part of most leave policies. If there is no other written policy on it, then you can only terminate coverage at the end of that 30-day grace period. So sometimes it'll just be easier for an employer to just simply go ahead and pay the employee's share of the premiums during periods of FMLA. And in those cases, if the employee doesn't return to work, then you can recover your share or the employee's share of those premiums. And if FMLA or coverage lapses during the FMLA period, if the employee returns to work, you have to reinstate coverage upon the return to work without any requalification requirements. You can't, have them satisfy a waiting period again or an initial measurement period. Even if their coverage lapses during the leave period, they can get it restated upon their return to the company. So how does FMLA interact with COBRA? This is often where it kind of gets a little messy. The one thing that is clear is that FMLA, the qualifying event does not occur until the end of FMLA. You don't have a COBRA event at the beginning of FMLA unless, of course, there's COBRA for another reason, like the child ages out of the plan, there's a divorce, something like that. The qualifying event occurs once the employee fails to return to work after the expiration of FMLA. And of course, employers are entitled to follow up with employees during the leave period. And if an employer is checking in with the employee, asking him about his intent to return to work, and the employee says, look, I'll tell you right now, I'm not coming back, then you can potentially consider the qualifying event to have occurred at that point. Once the employee advises the employer he's not returning, there's really no further right to FMLA at that point. In the COBRA period, the duration is measured from the date that the coverage is lost. Here's another important point about COBRA, and this is maybe the issue we see most frequently, is that when an employee owes some money for their coverage, maybe they didn't pay as they went and the employer just decided to front some of the money, you cannot condition the offer of COBRA upon the employee repaying those back premiums. That's a separate issue. You can kind of pursue the employee separately on that. But when FMLA ends and the employee does not return to work and coverage has lapsed, then they should be provided the qualifying event notice and the election form at that time. So how does FMLA get enforced? The main circumstances are employee complaints to the Department of Labor, an employee initiating a private action to pursue their FMLA rights, or due to complaints to the DOL, you might have direct enforcement action by the DOL itself. There are a number of ways employees can recover when it comes to their FMLA rights. They can recover lost wages and benefits. If they didn't get care because leave was denied, they can get the cost of care. Interest applies. Liquidated damages, which is another way of fancy way of saying damages that are difficult to calculate. They can sue for reinstatement and promotion, and they can also get attorneys and expert fees included in that number. So before I open it up to questions here, we include this at the end as a little kind of a cheat sheet or a chart as to what to do in situations where you think that there might be an FMLA situation. And so it breaks down into two buckets here. We have times when an employee calls in and he gives a reason for his absence, or he just fails to call in, or he calls in but doesn't provide a reason for his absence. So the first branch here, we'll talk about employees who call in and they give a reason for their absence. And here it's pretty simple. If the reason is an FMLA qualified reason for the absence, then you simply give them the FMLA notice within 5 business days. Or if he calls in but the reason is not FMLA covered, maybe he just has a stomach ache, he has to take the cat in to the vet. It's not FMLA covered, and you would just then revert to your standard company policy as to what happens when an employee calls in and doesn't have an FMLA covered reason. The example would just be counted as an absence. It would be counted as a vacation day, however you structure it at your company. A little trickier is when the employee calls in and he doesn't provide a reason for the absence, or he simply fails to call in entirely. And here it breaks down into 2 categories where the company either knows or doesn't know why the employee is out. And so here, if the employee just fails to call in, or he doesn't give you a reason, and you don't know why he's out, then you would, again, revert to your company policy for what happens when employees fail to call in, or they call in and they don't give a reason for the absence. So it will be counted as an unexcused absence, be docked a day, those kinds of courses of action. But it's also possible that an employee could not call in, but the company might know why the employee is out. Maybe he has a friend at the company who informs the manager. Maybe there's could be a car accident that makes the news, and so they know why he's out, even though he didn't call in. And there, in those cases, the employer does have an obligation. If it's an FMLA-covered reason, you need to send out the FMLA notice within 5 business days. Or you know why he's out, but it's not an FMLA-covered reason. You would, again, revert back to your existing policy for unexcused absences. So those are our prepared slides for today. I see we have a bunch of questions. I'm going to leave this slide up here for a little while. Here are the SHRM and, I believe, HRCI credits. So go ahead and write those down. Apologies. I hope these are the right program IDs, because these are the ones from last month. If for whatever reason they don't register, just let your MMA point of contact know. But hopefully they will work. So I do have a bunch of questions, and I'm going to just kind of take them in order here. And again, please feel free to type them in through the chat box. So first question is, does the employee also need to be located within 75 miles of the work site to be eligible for FMLA? No, that test is just testing to see how many employees the location has. And even if the employees drive in from over 100 miles away, the work site itself could still be covered if there's a sufficient number of employees. Next question is, just to confirm company eligibility to participate, my company has 47 employees in New Jersey and 4 in Texas. Assume we are not eligible because we do not have 50 individuals employed within a 75-mile radius of the work site. I was not a geography major, but I am pretty comfortable saying that Texas is not within 75 miles of New Jersey, and so it doesn't sound like that you would have, that you'd be FMLA covered under those facts. Next question is, what about if we as an employer don't consider the employee's reason to be a, quote, serious health condition like cosmetic surgery? Can we deny it even if a physician completes the FMLA application? And I believe I mentioned this when we actually had a slide on it, that cosmetic surgery is not an FMLA covered reason unless it involves inpatient care or there's a complication that itself rises to the level of an FMLA covered reason. So generally, no. Generally, the cosmetic surgeries are not covered reasons. Next question is, would you repeat the qualifications for employees who work for the same employer in the birth of a child? Also, what is the time period within which this leave must be taken? I don't want to spin back to the other slides because I want to leave this one up. But basically, when employees who work for the same employer have the birth of a child, they split the 12 months of leave unless it's a serious health condition of the child. Then they each get their own 12 weeks of leave. The leave to bond with a newborn or a newly placed child for adoption must be concluded within the first 12 months following the birth. Next question is, what if an employee is out of work 3 months prior to birth due to pregnancy-related issues? What happens when it is time for giving birth and the 12 weeks have been used? No more FMLA. Can you terminate employment legally? I don't really want to advise on termination issues through an open forum like this. We would always recommend you talk to your own counsel before taking adverse employment action, particularly against a pregnant employee. There may be state leave issues to consider as well. So this one, I think we'd want to take a look at the facts just to make sure we're on firm footing before terminating an employee in this situation. This one I'm definitely adding to my slide deck in the future. And this one is regarding reasons that don't qualify as FMLA. What if you have a service animal that is ill? Would that still not be protected by the FMLA? I love the question, but no, even if it's a service animal, even if you paid your $100 fee to get your service animal certificate, that would not be a protected reason, even though we love our animals. Next question is, we have 19 locations. Only 3 are within 75 miles of each other. Each of those 3 have fewer than 50 employees, but cumulatively they have more than 50. Would those locations fall under FMLA? Yeah, I think so. We have 3 that are within 75 miles and have a total of more than 50 employees, that sounds like you'd be a covered entity for those locations. The question regarding presumptive conditions, we require medical certification for every request so as not to be perceived as requiring documentation on a person-by-person reason. Should the presumptive illness or condition not be held to that standard? So it's a good question. I don't know off the top of my head. My inclination is that you can still require a medical certification. That's a good one. You can send that in to your MMA point of contact, and I can take a little closer look at that one and maybe follow up in an email. Next question, gastric bypass surgery, is that a covered serious health condition? It may be. If it results in inpatient hospitalization, then it certainly could be considered a serious health condition. On cosmetic surgery, would being restricted from working due to the possible injury or the potential to have complications following a surgical procedure be sufficient to qualify for FMLA? Generally, no. But again, in these situations, it really is very fact-specific, and I would recommend you talk to your labor counsel, or we're always happy to help as well, to really look at the facts of those situations. Under the choice of doctors, what type can the employer reject rather than listing all that can be accepted? You generally need a good reason for rejecting an employee's choice of physician. That's another one that's going to be very fact-sensitive, and you should be talking directly to your counsel if you feel that, for whatever reason, you don't want to accept the employee's choice of physician, or you feel it's someone inappropriate to be commenting on their particular condition. You know, they have a note from the eye doctor when they went and had dental surgery. You know, those kinds of things you can further investigate. Next question is, say the certification says the associate needs leave until May 31st, but the disability carrier only approves disability through March 15th. What date should be reflected on the designation notice? You know, if the medical doctor is approving it through May 31st, then it would be May 31st, even though the disability plan payments are going to stop March 15th. As I mentioned, even though an employee might not qualify for disability payments, it doesn't affect his eligibility or entitlement to FMLA. If you're requiring an employee to report every 30 days, what can you do if they do not report? You know, if they're unresponsive to your requests and you're not aware that they're in a coma, you may have an avenue for denying further FMLA coverage. But again, you know, when you're kind of dealing with these one-off scenarios, you should really talk to your counsel before you take adverse action against an employee who's on FMLA. Next question, staff is given a bank of PTO in January with an accrual rate of 0.417. Can we use for paid leave? Yeah, I mean, that's PTO. That's paid leave. You can require employees to substitute it as permitted under the FMLA. If an employee is on intermittent FMLA, can vacation be used in 1-hour increments? Yeah, generally yes. I know there are some rules with regard to substitution of vacation. You know, if the employee is, you know, taking FMLA for a couple of hours intermittently, you can't make him burn a whole day of vacation. But all things being equal, you can generally use 1-hour increments for intermittent FMLA. Can you require an employee who's on workers' comp to take paid time off concurrent with FMLA leave? That's another good question. If it was payment under a disability plan, you can't require the substitution of paid time off. I don't recall off the top of my head whether workers' comp is included in there. Again, if you'd like, submit that one to your MMA point of contact, and I'll see if I can look that one up on the back end. I don't want to talk out of school on that one. I'm not sure about that. Next one is if an employer pays, meaning self-insures short-term disability, can the employer still require concurrent use of PTO, which is also employer paid? No, because the fact that the employee is receiving STD benefits means that his leave is not unpaid, so you can't then require the substitution of the PTO. He's already getting paid. He can voluntarily allow the employee to top it off and substitute the paid leave, but you can't require it when the leave is already being paid. Can you expand on the disability benefits and accrued benefit time? I had an employee on leave who used all available sick time and accrued vacation time. Disability benefit covered all time out of work except sick time. I am not sure what the question is there. It sounds like the employee still has an entitlement to unpaid FMLA, even if he previously burned all of his sick time and accrued vacation time. If you decide to extend the 12 weeks, then you now set a precedent, and must you offer the extension to all other employees? I would say from an employee relations standpoint, if you're extending the 12-week leave period, you want to do so on the same scale for all similarly situated employees, simply from an employee relations standpoint. There are also other rules regarding when you have leave policies in connection with FMLA. So this is another one where you should talk to counsel that drafted your FMLA policy, and if you want to amend it to extend the 12 weeks, they can take a look at your existing leave policies and kind of see if any corresponding changes need to be made. Last question before we conclude for today. I'm sorry we weren't able to get to all of these questions. Last one is the employer responsible for the employee's portion of medical insurance while the employee is on FMLA? And the answer is no, unless the employer has somehow obligated themselves to doing the catch-up contribution method. And some employers might have in their handbook, look, we're going to cover your premiums while on FMLA, and we'll get them back when you return. That would really be the only time the employer is responsible for the employee's portion. Otherwise, it's really up to the employee to go ahead and make sure his premiums are being paid on time. That brings us up to 3 o'clock. I want to thank you all for participating. If you have any unanswered questions, go ahead and send them in to your point of contact at MMA. We'll do our best to get them addressed. And I believe that we're also making a copy of the PowerPoint available. Again, I think you have to go to your MMA point of contact for that, but we're happy to share it. So again, thanks for participating, and hope to talk to you all again next month. Have a great day.